table. In the name of Akhtar and Secretary of State for the Home Department.
Yes, Mr. Mackenzie.
May it please the Court, I represent the appellant. My learned friend Mr. Tabori represents the Secretary of State. The Court should have an appeal skeleton from each side and also a supplementary skeleton from each side in which we've addressed the status of the permission judgment.
Yes.
Which we'll perhaps come back to. A core bundle, a supplementary bundle of evidence and an authorities bundle, I hope. And my learned friend has just circulated further authority, which I think he may wish to take you to in due course.
Right.
As the Court will have seen, the appellant is a 62-year-old Pakistani woman. She's lived in the UK since 1985, and she faces deportation in light of her conviction in 2016 for various offences of dishonesty. She received a number of custodial sentences, all of them between 21 and 30 months. And the sole ground of appeal on which we have permission relates to the upper tribunal's treatment of the very compelling circumstances test in section 117C6 of the Nationality, Immigration and Asylum Act. And to put our case in a nutshell, it's that when conducting the full proportionality assessment under Article 8, which it was required to conduct, the upper tribunal failed to take into account all the relevant matters that it should have taken into account. As the Court will also have seen, this was a case where the tribunal had previously been found to have erred in law in terms of aggregating the sentences the appellant had received, which isn't permissible. And the upper tribunal had then retained the case for itself in order to reach a de novo substantive decision. Now, the background facts are summarised, I hope, uncontroversially at paragraph 9 onwards of my skeleton. The appellant was born in 1961. She arrived in the UK as a fiancée in April 1985, and she was granted indefinite leave to remain later that year. I should say there are one or two references in the papers to her getting ILR in 2000, but I think that's an error. It was fairly soon after she arrived. Her husband is a British citizen. He had set himself up as a spiritual leader, and he was the founder of a religious institution in Stoke-on-Trent, which the applicant was also involved in. And although that institution was accepted to be a genuine one, it was also misused because it had been used to underpin a system of mortgage fraud, orchestrated, it seems, by the appellant's husband, in which I think around 10 people, including both the appellant and her husband, were convicted. And in brief, part of what seems to have happened is that the funds donated by members of the congregation were misused as a basis for the fraudulent purchase of properties. As I say, the appellant received a total of 4 sentences, some to be served concurrently and some consecutively, none of them exceeding 30 months. The exact details, if you require them, are at page 25 of the core bundle at paragraph 13 of the tribunal's judgment. I wasn't going to take you there now because I think the contents of those offences are not controversial. And because none of her sentences exceeded 4 years, she fell to be considered as what's been called in the case law a medium offender, as opposed to a serious offender, which is anybody convicted and sentenced to more than 4 years in a single sentence. 4 years or more, I should say. She was released from prison in June 2018. Her husband, who, as I say, had been convicted as the main orchestrator of the fraud, he received much longer sentences. He was still in prison at the time of the tribunal hearing, although he's since been released. And he and the appellant's children and grandchildren were British citizens. The appellant appears to be the only one in the family who wasn't. And they all lived close to one another in Stoke-on-Trent. And it was the appellant's relationship with those family members and the absence of any immediate family, stressing immediate family, in Pakistan which was one of the key points that the appellant relied on in her appeal, along with, amongst other things, her poor health, particularly her poor mental health. And I'll come on to all the details of that, if I may, when we look at the upper tribunal decision. So that's a broad outline of what the case was about. Now, the court will be familiar, I'm sure, with the relevant statutory provisions. I've summarised those at paragraph 3 on my skeleton, and if you need them in the authorities bundle, they're at tab 17, page 352. And perhaps I'll just dwell on those for a few moments, if I may, because the precise meaning of those, the application of them to these facts is obviously the key issue between us. So under section 117C1, deportation of foreign criminals, which includes for present purposes anyone sentenced to more than 12 months, 12 months or more, is declared by Parliament to be in the public interest. Subsection 3, the public interest is declared to require the deportation of what's, as I say, been called in the case law a medium offender, someone sentenced to between 1 and 4 years, unless one of two statutory exceptions apply. And those exceptions have been described in the case law as a shortcut to a favourable result for the appellant. That's the phrase used by Lord Justice Underhill in HA Iraq, which we'll come on to look at in a moment. So in essence, the first of those exceptions in subsection 4 comprises specific issues relevant to a person's private life, specifically their integration in the UK, well, their length of residence, first of all, in the UK, their integration in the UK, and any obstacles they would face on removal to their country of origin. And the second exception in subsection 5 comprises issues relevant to family life, and in particular to the effect on a partner or minor child of deportation. So either of that person or people having to leave the UK with the deportee, or being separated from the deportee if the deportee leaves alone. And a qualifying child, of course, is defined as a child who's a minor. That's in section 117D1. And perhaps I could just highlight at this point, and again I'll come back to this in a moment, that subsection 5 does not include the effect of separation on account of deportation from any adult children, even when there's a strong element of dependency. And also in the case of a deportee who's got a spouse or partner, it's the effect of separation on the partner, which has to be taken into account under subsection 5, not the effect on the deportee themselves. And it's also worth highlighting, perhaps, again because it's very relevant to something which I'll have to return to, that these provisions in subsection 4 and subsection 5 are very much, as it were, all or nothing provisions. The appellant either has spent half their life lawfully in the UK or they haven't. The obstacles they would face either would be or are classified as very significant or not. There either is an impact on their spouse or partner which is unduly harsh, or there isn't. So there's no scope under these subsections for giving weight to matters which fall short of those thresholds. So an appellant can't argue under subsection 4, for example, that they've spent a substantial proportion of their life, but less than half, say 40%. That's not relevant as far as subsection 4 is concerned. They also
and similarly, I suppose it has nothing to do with the length of time. So you could be someone who's 60 and spent 29 years here.
Absolutely.
As distinct from somebody who's 20 and has spent 10 years here.
Indeed, my lord, or indeed you could be 60 and have spent 31 years here, but only half of that lawfully. So the unlawful period of residence would be entirely irrelevant as far as that subsection is concerned. And an example, again, we'll come back to this, but an example given by Lord Justice Underhill in, I think it's HA Iraq, is you can't argue under subsection 4 that you would face some obstacles on removal unless they are very significant obstacles. So significant obstacles, but not very significant obstacles, would be irrelevant. Likewise, you can't argue that there would be an impact on a child who's not a minor. So that sort of consideration simply is not relevant as as far as subsection 4 or subsection 5 are concerned, it can't be given any weight at all. And as I say, to that effect, perhaps we could just turn up Lord Justice Underhill in HA Iraq. In the authorities bundle, if you're working on a hard copy, it's tab 14. It's page 248. Tab 14, page 248. And it's the last two lines of page 248 in 29A. And this is a passage quoted with approval in the same case in the Supreme Court by Lord Hamblin. Lord Justice Underhill says, in the cases covered by the two exceptions in subsections 4 and 5, which apply only to medium offenders, the public interest question is, over the page, answered in favour of the foreign criminal without the need for a full proportionality assessment. Parliament has predetermined that in the circumstances there specified the public interest in deportation of medium offenders does not outweigh the Article 8 interest of the foreign criminal or its family. They are, so to speak, given a shortcut. The consideration of whether those exceptions apply is a self-contained exercise governed by their particular terms. In addition to that, Lord Justice Underhill then goes on in the next part of the same paragraph, B, to say that there's also a requirement, if the particular terms of those exceptions are not met, to carry out a full proportionality assessment. That's line 3 of subparagraph B. According to, and that's obviously under section 117C6, according to which, of course, a person can escape deportation if there are very compelling circumstances over and above those described in exceptions 1 and 2. And although, of course, on its face, section 117C6 only applies to those sentenced to more than 4 years, to so-called serious offenders, it's been established that it also applies to medium offenders. That's NA Pakistan. I think I don't need to take you to that because I think it's not controversial, but if you need it, it's paragraph 24 and 25 of NA Pakistan at page 159 of the authorities bundle. So if you don't meet the two exceptions, whether or not you're a serious offender, you can escape deportation by showing that there are very compelling circumstances. Now, as to that test, as I've said at paragraph 5 of my skeleton, Lord Hamblin in the Supreme Court, perhaps we could just turn this up, page tab 15, page 306. This is H.A. Iraq in the Supreme Court. Right at the bottom of 306, Lord Hamblin, and the top of the following page, Lord Hamblin confirms that a full proportionality assessment is required in which all relevant circumstances, line 2 of paragraph 51, all relevant circumstances taken into account cumulatively. Secondly, it's important for my argument that the weight to be given to each matter is for the decision-making tribunal. And Lord Hamblin says this at page 308 in the same case, page 308, paragraph 58. At the beginning of that paragraph, which I hope is sidelined for you, given that the weight to be given to any relevant factor in the proportionality assessment will be a matter for the fact-finding tribunal, no definitive statement can be made.
Give me a loss where you are now.
I'm so sorry, my lord. I'm at page 308 of the authorities,
yes.
Paragraph 58.
58.
So there should be a sideline at the top of that paragraph. Given that the weight to be given to any relevant factor in the proportionality assessment will be a matter for the fact-finding tribunal, no definitive statement can be made as to what amount of weight should or should not be given to any particular factor. It will necessarily depend on the facts and circumstances. Now, I stress that that is a different approach to the approach under exceptions 1 and 2, where it's not a question of varying weight being given to different factors according to the judgment of the tribunal. It's simply a question, as I said earlier, of whether certain specified factors are present or not, whether certain thresholds are met or not.
And do you say that the weight to be given to the public interest in favour of deportation as a result of committing an offence is confined to categorisation as either a medium or a serious offender. What I have in mind is that somebody could be a medium offender who is sentenced to 8 years imprisonment by a series of consecutive sentences, none of them amounting to 4 years, whereas somebody could be a serious offender if they only get 4 years imprisonment with one count. But one would think that the overall criminality of the former person is greater because they have merited a total sentence of 8 years. One would think, therefore, there might be a stronger public interest in deporting that person than in the serious offender who's only got 4 years. But
well, one might, my lord, but the statutory scheme doesn't say that. The statutory scheme is very much dividing people into these two categories of offender, depending on the length of the longest sentence that they receive. And it is a peculiarity. Indeed, one might think of somebody who had committed, say, half a dozen offences for which they received 3 years on each occasion. According to the statutory framework, that person would fall to be treated in the same way as somebody who'd only offended once and only got 1 year. And that is a peculiarity of it. But as Lord Justice Underhill says, this is intended to act as a shortcut. It's intended to make it more straightforward in some cases to succeed, to bypass the need for a full proportionality assessment. And obviously that, it works in both ways. It can work in favour of some offenders, and it can work against others. If an offender is right at the bottom of the category and has received only 1 year for one sentence and is assessed by all and sundry to present no risk of reoffending, they get treated in the same way as somebody who's a much more serious offender and is a risk.
well, the medium offender who can satisfy the satisfying exception
Yes.
gets the advantage of the shortcut.
Yes.
But the medium offender who can't satisfy the exception
Yes.
goes for a full proportionality
Oh, I see.
assessment,
Mhm.
in which case is it relevant to look at their overall criminality?
I think that would have to be correct, my lord, because of 117C2, the more serious the offence committed by a foreign criminal, the greater the public interest in deportation. But of course that wasn't a point taken in this particular case.
No, fair enough.
Maybe that should have been, but it wasn't. And of course this appellant, even if one looked at all the offences she'd committed, was only just over the 4-year threshold, so she was very much at the bottom of that bracket, and she was assessed to be a low risk to the public. So all of those, and we'll come back to that point as well, the risk to the public, but all of those would have to go into the pot as well. The point my lord has made, I respectfully accept in principle, but on the facts of this case, probably not one which goes against this appellant.
Yes, well, you're right. She was only just over 4 years.
Yes, I'm grateful for that. The next point I just wanted to make was that, again, an important aspect of my case is that the matters which have to be taken into account in the appellant's favour do include matters which would fall within, or could potentially fall within, subsections 4 and 5, such as social ties, effect on a spouse, effect on a minor child, even if the specific thresholds in those subsections aren't met, and that's NA Pakistan. Perhaps I could just ask the court to turn to tab 8, page 160. Perhaps rather than reading it out, I could invite the court to read from line 2, from the phrase used in section 176 to the end of paragraph 29, please.
Sorry, which bits do you want us to read?
Sorry, paragraph 29 at the top of page 160,
Yep.
from line 2, from the phrase used
Thank you very much.
to the end of that paragraph. And then Lord Justice Jackson, this is Lord Justice Jackson, of course, he looks at the situation of serious offenders, obviously not this case, and then picking up on medium offenders, paragraph 32, perhaps I could just ask the court to read 32 at the bottom of 160 over to 161.
That doesn't take the matter any further than what Lord Hamden said, does it, in H.A. Iraq?
No, I mean, indeed, he cites these passages with approval, yes.
Yes.
So, no, it doesn't. And then just finally on NA Pakistan, these principles are illustrated by what actually happens in the facts of the first appellant. If one goes to page 166, please. Paragraph 58. The court held in the first two lines of 58 that the decision of the tribunal in that case has been wrong in law because, line 3, the tribunal thought that any matters relevant to the question whether NA fell within the circumstances described in exception 1 and exception 2 could not be relied upon in showing that there are very compelling circumstances relevant to the test in subsection 6. For the reasons that we've given above, that is not correct. Matters relevant to an assessment, whether a case falls within exception 1 and 2, may also be relevant to an assessment under section 117C6, whether there are very compelling circumstances. And as I've said at paragraph 7 of my skeleton, we say it's inherent in all that matters which would not by themselves preclude deportation, in fact which might not come anywhere near doing so if one looked at them in isolation, nonetheless may do so if they're taken together on a cumulative and multifactorial basis. And again, that's clear from Lord Justice Underhill in H.A. Iraq, paragraph 60, that's page 260 of the authorities bundle. And he says at the top of page 260, there may be cases where a tribunal is satisfied that there's a combination of circumstances, including but not limited to the harsh effects of the appellant's deportation on his family, which together constitute very compelling reasons sufficient to outweigh the strong public interest in deportation, but where it may be debatable whether the effect on the family taken on its own, as subsection 5 requires, is unduly harsh. An equivalent situation could arise in relation to exception 1. There might, say, be significant obstacles to the appellant's integration in the country to which it proposed to deport him, but it might be questionable whether they were very significant. And as I've also sought to submit in paragraph 7 of my skeleton, from line 4 of paragraph 7, the weight to be attached to individual factors in the holistic analysis under subsection 6 may be different to the weight given to the same factors in the narrower or shortcut approach applicable under subsection 4 or 5. So when exception 2 is considered under subsection 5, as I've already said, there either is or there is not an unduly harsh effect of deportation on a spouse or minor child. And that effect is either of decisive weight in the appellant's favour or it's of no weight at all. If the effect on the spouse, just taking the spouse for the moment, if the effect on the spouse doesn't meet the unduly harsh threshold, any other effect, any lesser effect on the spouse is simply discarded. It's simply not relevant for purposes of subsection 5. Whereas under subsection 6, an adverse effect on a spouse or child may be given some weight according to the judgment of the decision maker, even if it's not by itself conclusive of the appeal. So there's scope under 6 for varying amounts of weight to be given to certain factors which isn't present in 4 or 5, we say. And then the last case, which may be worth looking at on this point, is a case called Yelchin, which is this court's, I think, most recent, one of the most recent verifications of the law. It's tab 16, and it's again Lord Justice Underhill, and the passage I wanted to look at is at page 344. And just for context, this is a serious offender case, so some of what Lord Justice Underhill says needs to be adapted to the circumstances of this appeal. We can see from paragraph 58 that Lord Justice Underhill says in line 2, it's in my view inherent in section 117C that a serious offender will need to meet a higher threshold than a medium offender in order to satisfy the test in subsection 6. Very compelling circumstances. But with that in mind, perhaps I could ask the court just to read in paragraph 62, again, the passage which I hope is sidelined for you, beginning at line 5, at the end of line 5, please. So the essence of our complaint is that the tribunal doesn't do what the case law says it has to do under 6, and I'll hope to demonstrate this in a moment, that it doesn't take account of all the relevant factors in combination, in particular including matters which fall within the scope of subsection 4 and 5, and or if it did consider them, it doesn't, as Lord Justice Underhill says there that it should, identify whether it gave them significant weight in reaching its overall conclusion. And then finally on the authorities, my learned friend cites a number of cases in his skeleton. In my submission, none of those affect the fundamental test, which has now been fairly clearly explained by the Supreme Court and by this court. Indeed, with respect, they would appear to be cases which revolve around their particular facts.
I'm happy to pick up on something you just said there. My understanding of what Lord Justice Underhill said in 62 is, it is no doubt also desirable that it should indicate
yes.
the relative importance of those factors, but there are limits to the extent to which that is practically possible. Factors in play are incommensurable and calibrating artificial exercise.
Yes.
So that doesn't support what you've just said.
I was referring to the sentence just before that where he says a tribunal must identify the factors which it's given significant weight in reaching its overall conclusion.
Yes.
We say it didn't do that. So I mean
I think what you're suggesting is that because the factors relating to 5 weren't mentioned, therefore the tribunal's reasoning was deficient, or they didn't take them into account. Is that what you're saying?
yes, when it came to look at 6, yeah.
Right. I don't get that from this passage.
Well, the particular sentences I wanted to look at is the multifactorial approach,
Yes.
and the need to identify the factors to which the tribunal has given significant weight.
Yes.
That's no more or less than that.
Yes.
But I mean, I think it's not controversial that it does have to take account of all relevant factors, and the concern is not so much that it didn't precisely calibrate, as Lord Justice Underhill says there. The concern is not that it didn't precisely calibrate the relevant factors; it didn't consider them at all.
So your point is the tribunal should identify the facts it gives weight to,
Yes.
but it doesn't need to go further and say, I give this substantial weight, I give this less weight.
Yes,
Something like that.
I'd accept that. But
Yeah.
yes, absolutely, and that's not our challenge. I certainly hope that's not how I've put it across.
But the difficulty is, as Underhill mentions, in an exercise which involves looking at all circumstances, you can't mention them all.
No, but one has to mention the crucial ones,
Yes.
and one has to indicate what weight, broadly what weight, not precisely, but broadly what weight. One
So
gives them.
you have to satisfy, do you, that the factors they didn't mention were crucial,
Potentially crucial, at least.
potentially crucial.
Material in the sense that they could have made a difference. Yes.
But what if the tribunal didn't think they made a difference?
Well, then it should have said so, and doesn't.
But why, if they don't give them significant weight?
Because they were factors which were very much to the fore in the case, such as the appellant's mental health, such as her relationship with her adult children. And it was required as part of its reasoning process to say, well, we do or we don't give weight to these factors.
But if the tribunal took the view that the only factor that could, taking all the other matters as read, propel this into the very compelling circumstances category, were the factors it did consider and didn't think were enough, then does it have to say that? Does it have to identify every other possible factor and say we don't think those were sufficient in combination with that?
Well, as a general principle in my respectful submission, it has to identify its conclusions on the main issues in dispute, and it was certainly the appellant's case. I mean, obviously the appellant wasn't represented at the hearing,
Yes.
as you'll have seen, but certainly in the skeleton argument, which I produced and which they did have before them, these matters were mentioned. And
So this is really a reasons challenge.
yes, it is.
Do we have your skeleton argument for the upper tribunal hearing in the bundle somewhere?
It isn't in the bundle. No, I don't think so. I mean, I can certainly provide it.
I think that might be useful because the upper tribunal do refer to it more than once.
Yes.
So yes, please.
Shall I email it now, or
Is that something you can do instantly, or
within a minute or so? Or shall I do it after? Well,
why don't you do it when you've completed your submissions?
I'm grateful. Yes, I was just briefly saying that my learned friend cites a number of cases. I will happily respond to those in due course, but in brief, in my respectful submission, they don't take matters any further. They don't say anything further about the principles. They are applications to the facts, as far as it's possible to see, and for some of them are serious offender cases and therefore not of direct relevance. So, coming on to the tribunal's judgment, what does it in fact take into account under the heading of very compelling circumstances? So, for the context to its consideration of that point, I'd like to begin, if I may, at page 47 of the core bundle, at page paragraph 58, which is where the tribunal starts its assessment of the appellant's convention rights. And this is where in this following passage is where it identifies the matters which have been advanced to it as relevant. And essentially the point I'm going to make is that it deals with those matters under subsection 4 and or subsection 5, but then it doesn't go on to deal with them under subsection 6. So it starts by asking itself whether the appellant has established a family life in the UK, refers to her arrival in 1985, her marriage, over the page to her British children, says she was granted ILR in 2000. As I've said, I think just for sake of accuracy that's not correct, it's 1985. Paragraph 59 accepts that she's established a family life with her husband. Line 6 accepts that her son Altaf, who's now 25, continues to live with the appellant, and as we'll see, Altaf was the son who has various physical and cognitive disabilities. It refers about 10 lines into that paragraph to the report of Amy Goddard. She was an occupational therapist, and it said that it shows that the appellant and Altaf are both dependent on each other. And then
quite an important finding in relation to Kugathus, that there are more than normal emotional ties between the appellant and her son.
Yes, indeed. Indeed. Obviously, that wouldn't necessarily have been relevant to her private life, to her family life.
No, but it is an important
Yes.
finding, nevertheless, when one's looking at Article 8.
Yes, indeed, my lady. I'm grateful. It absolutely is. And they, having cited, as my lady has said, Kugathas and referred to the facts, they accept just over halfway down that paragraph that the appellant enjoys family life with Altaf, as well as the husband. And then about 2/3 of the way down, paragraph 59, about 8 or 9 lines up from the bottom, as far as the appellant's relationship with her other children cannot be described as family life, it points to the appellant having a strong private life in the UK, and again accepts that Article 8 is engaged on that basis, accepts the legitimate aim, of course, and then finishes the paragraph by saying that the central issue in this appeal is whether the deportation, decision to refuse leave to remain, by which I think it must mean the decision to deport, because obviously she already had leave to remain, whether the decision to deport is proportionate to the legitimate aim. Paragraph 60.
So apart from that criticism, is there anything you would criticise in paragraph 59?
No. I mean, I don't have a challenge to the individual findings of fact, so I'm simply going to take the court, if I may, through what I say
that's helpful.
matters which they resolved in the appellant's favour, and which they should then have gone on to take into account under subparagraph 6, subsection 6. Then, I mean, none of this is by way of criticism. This is simply by way of, as it were, run-up.
Exposition.
Yes,
yeah.
Indeed. 60, it reminds itself of the structured approach required. 61, it notes that she's a foreign criminal as defined, hasn't been sentenced to any period of imprisonment more than 4 years. And the last couple of sentences under 61, in 61, applying 117C3 of the 2002 Act, the public interest requires her deportation unless exceptions 1 or 2 apply. We therefore first proceed to consider whether she's exempt from deportation as a result of the private or family life exceptions set out in those subsections. Doesn't at that stage remind itself of subsection 6 or the very compelling circumstances test. But at paragraph 62 onwards, it gives reasons for concluding that neither exception 1 nor exception 2 is met. And as I say, in the course of doing so, it makes a number of findings of fact, some of which are favourable to the appellant, some of them are adverse to her, or at least some of them are partially favourable anyway. And as I say, for purposes of trying to make my point that not all relevant factors were taken into account, I'd just like to highlight, in the order in which the tribunal makes them, the points of fact that the tribunal did wholly or at least partially resolve in her favour. So first of all, her long residence, paragraph 62 at the bottom of page 49, it accepts, as indeed wasn't in dispute, that she'd arrived in 1985, aged 23, and therefore had been resident for some 37 years by the date of the hearing. Tribunal accepts that she met the criterion in subsection 4A of being resident in the UK most of her life. In fact, of course, the test was whether she'd lived here lawfully for most of her life, but that wasn't in dispute, so that must be what the tribunal...
As you say, in the paragraphs you're about to take us to, the tribunal make some favourable findings and some adverse findings,
absolutely,
including the adverse findings, things like not socially and culturally integrated and not unduly harsh, etc. When they get to the overall proportionality assessment under subsection 6, you'd expect them to take account of the adverse findings as well as the favourable ones, wouldn't you?
Well, I suppose they would have to, yes.
Yes, but they don't actually.
They don't do either.
They don't actually mention them either.
No.
And it seems rather inconceivable that they didn't have them in mind.
Well, it's very hard to know what they did have in mind, other than looking at what they say, which is that they don't. What they say, or rather, what they don't say, which is that they don't mention the matters. They don't appear to recognise that they are relevant.
So they don't appear to recognise that what are relevant?
The matters which they've just taken into account under subsection 4 and 5.
What about section 94, paragraph 94? So considering subsection 6, they say we are prepared to accept the appellant has a strong family and private life in this country. We have no doubt that she enjoys a strong relationship with all her children, but the focus of the evidence before us is upon the impact of the appellant's deportation on the care and assistance she provides her son, Akhtar.
Yes, indeed.
So they have taken into account her family life and private life.
They've taken into account her relationship with her children. They don't there take into account her mental health. They don't there take into account her relationship with her husband. I mean, this is what I'm going to. I mean, I will come to 94. But
Why isn't that encompassed within strong family and private life? The relationship with the husband.
Well, in my submission, it has to do more than simply say she has a strong family and private life, without elucidating what it means by that. It would appear.
But they've already done that, haven't they?
Well, they've done that in a different context. They've done that in the context of asking themselves, are the relatively elevated thresholds in subsection 4 and 5 met? They aren't asking themselves that in the context of having to engage in this, as I say, multifactorial assessment of the relevant matters, in which they have to decide in broad terms what weight to give, varying amounts of weight to give to these individual factors. So this is why it's crucial to my argument to say that the test to be applied under 4 and 5 is different to the test to be applied under 6, and why it's relevant for my argument to highlight the point that Lord Justice Underhill makes, where he says, for example, that you might have significant obstacles which are not very significant. So if they are not very significant obstacles, they are not relevant for purposes of subsection 4, but they may still be relevant for subsection 6. So it's not sufficient, in my submission, for them to have looked at these matters under 4 and 5. They've got to look at them again under 6, because the approach is different. The question of what weight to give them is different, and the threshold to be met is different. But as I say, I will come back to 94 in a moment. I was just going to look at what it makes of family ties, which is at page 50. Paragraph 65, having quoted this court in CI Nigeria, limited evidence regarding her social and cultural integration, and then line 4, the entire focus of the appellant's life in the UK appears to be her devotion to her family and the care and support she provides to Altaf. It then refers to her involvement with the Darbar Unique Centre, which was the husband's religious institution, and at the top of 51, there's a reference to her helping to organise prayer meetings and other events. Further down 51, page 51, last 5 lines of 56. Again, we accept that since her release, she's maintained her relationships with members of her family, continued to engage in activities of positive nature through her continued involvement with the Darbar Unique Centre. But as I say, for reasons it does go on to give, which of course we don't challenge, it doesn't accept that all of that helps her meet the threshold of being socially or culturally integrated. The third set of relevant facts relates to her family ties in Pakistan, and the tribunal analyses those at some length at paragraph 70, page 53. And at the top of page 54, it finds that she and her family had sought to minimise her remaining ties to Pakistan. That said, it wasn't in dispute that all her children lived in the UK. Her own parents had passed away, there's a reference to that at paragraph 70, and that her siblings had either passed away or moved away from Pakistan. That's paragraph 72 and 73. So she did have extended family and in-laws, but no immediate family. And as to the in-laws, the tribunal finds that there were a number of those who could assist her on return. So page 60, paragraph 85, 4 lines from the bottom of page 60, she retains strong familial connections to Pakistan. They may not have the space available to accommodate the appellant for any significant length of time, but she would have, they say, at least some emotional support and accommodation available, but doesn't appear to reach any conclusions about how she could be supported or accommodated in the longer term.
I'm so sorry, Mr. Mackenzie. Which paragraph is that? Just my fault.
I'm sorry, 85,
Thank you.
page 60, the last 4 lines of paragraph, last 4 lines of page 60, I'm sorry.
Thank you.
So some family connections, albeit they may not be able to accommodate her for a significant length of time. Fourth relevant set of facts, her mental health. Perhaps we could just go back to paragraph 84 on page 60. Accepts that she suffers from depression and obsessive-compulsive disorder and requires the support of her family. So starting at line 3 of paragraph 84, we have no doubt the appellant is likely to be distressed and worried about returning to Pakistan, having lived in the UK for many years, except the diagnosis made by Dr. Wahid that the appellant has complex and challenging mental health needs and has been suffering from recurrent depressive disorder and obsessive-compulsive disorder, except she's taking regular antidepressants, and that her children are providing her with emotional and social support. And the tribunal had dealt with Dr. Wahid in a little more detail earlier on, and perhaps I could just briefly take you to page 43, page 50, or paragraph 50, I'm sorry, page 43, paragraph 50. Starting line 5 of paragraph 50, Dr. Wahid expresses the opinion that once the appellant is informed about her deportation to Pakistan, it will immediately lead to her coming under extreme stress, resulting in a further worsening of her mental health, an increase in the frequency of her obsessive-compulsive behaviours, increased risk to herself. He's concerned that the suicide risk would increase manifold. This may require increasing her medication, support from the crisis team, or even admission to a mental health unit. There'd be an increased risk upon arrival in Pakistan, where she would be under extreme stress, lonely and unaware of how to control her behaviours and seek help. In summary, he expresses little doubt that her prognosis would be poor, with a deterioration in her mental state, increasing the severity of symptoms, increasing the frequency of her OCD behaviours, and a heightened risk to herself. It's probably only fair to say that that was slightly tempered by what is said at the end of the previous paragraph, paragraph 49, which was that Dr. Wahid agreed that if she had some family support in Pakistan, that would help her and buffer some of the stress that she'd be under, albeit that would depend on the nature and quality of the support available. Then the fifth set of factors which we say are relevant, the difficulties she would face in Pakistan. Page 62, paragraph 87, the tribunal says at the top of 87, we don't accept it would be entirely unfeasible for the appellant to return to Pakistan, which seems quite a high threshold. Line 3, it says, again repeats that her relatives in Pakistan would provide at least some support. But it does accept, at the end of that paragraph, about 4 lines from the bottom of page 62, life in Pakistan will not be easy initially, but we don't accept that she could not cope. Having considered the evidence as a whole, while we accept that she would naturally encounter some hardship in returning to Pakistan, we don't consider that hardship to approach the level of severity required by section 117C4C, that should say.
This paragraph also contains conclusions about the impact of her mental health, in that although she has these problems,
Yes.
She'll be able to engage fully in life in Pakistan. She's got insight, she can cope, and she will get the medication that she requires, and treatment will be available to her.
Yes.
I mean, those were all challenged, but those are the findings that the tribunal makes.
Yes, absolutely. I'm not trying to pretend that the findings on that are wholly favourable to her, but there are findings which were capable of being relevant, we would say, to a holistic assessment of Article 8, which include an acceptance that there would be some hardship and some challenges. And as I say, I'll seek to show that they weren't taken into account when we say they should have been. But the point that I would just like to focus on there in the last couple of sentences of that paragraph is that it's the high statutory threshold that the tribunal finds is not met, the threshold under section 117C4. It's not that the tribunal thinks that she would have no difficulties at all. Then as to the likelihood of permanent separation from her husband, at page 63, paragraph 88, the husband had provided a letter saying that he couldn't relocate to Pakistan because of his very poor health. If you need to see it, it's in the supplementary bundle at page 82. But essentially he says that among other things he both couldn't and wouldn't relocate to Pakistan. He said he had a serious heart condition, he'd had triple bypass operation in prison and used a wheelchair, as the tribunal notes at paragraph 88. And at paragraph 90, they clearly accept that the husband couldn't relocate to Pakistan, and therefore that he and the appellant would be separated. And again, they don't accept that meets the unduly harsh threshold, so she can't succeed on that basis alone, but they don't say that it's not, there's no impact on him, or on indeed on her. So
I mean, they actually say a very long way from establishing unduly harsh. So
yes.
It's not a near miss case.
No, it's not. It's not a near miss case, but it is a case where there are a lot of factors to take into account. As I say, any of these factors taken by themselves couldn't and didn't succeed. I don't have any challenges to that. It's the question of whether one then needs to combine them and what the tribunal did in terms of looking at them cumulatively.
Incidentally, do we know the husband's release date? I think
He is out now.
he is out now, is he?
Yes. So he got a total of 11 years in the end, and he would have been in prison since about 2016, I think. That's when the sentences began. So yes, he is out now, I'm fairly sure. But he wasn't out at the time of.
I thought it said 2024. Yes, it says due to be released in 2024, but it didn't say anything more precise than that. But anyway, he's out now.
Yes, those are my instructions.
Yes, thank you.
So, as I say, I accept, of course, that some findings in her favour, there are some findings against it. The tribunal doesn't accept that she meets the thresholds in 4 and 5. But then what does it do with subsection 6? And it deals with that at paragraph 92 onwards, page 64. So heading is section 7C6. Appellant therefore fails to meet the statutory exceptions to deportation in every respect. What she must show if she is to avoid deportation on Article 8 grounds that there are very compelling circumstances over and above those in the exceptions to deportation which suffice to outweigh the public interest. Now, my learned friend would say that's the tribunal directing itself correctly as to the requirements of section 117C6. We would say that whilst the tribunal acknowledges what subsection 6 says on its face, it doesn't in fact direct itself as to what it requires in practice. And what it goes on to do, in fact, shows that it didn't understand what it requires in practice. It reminds itself at 93 of the strong public interest in deportation. 94, as my lord has pointed out already, it refers again to the appellant's strong family and private life. But that seems to be limited in terms of what it actually says to her relationship with her children. And that's clear from the next sentence. In my submission, we have no doubt that she enjoys a strong relationship with all her children, and then again a reference to Altaf. And it discusses at 95 and 96 the impact on Altaf of his mother's deportation. It records in those paragraphs essentially what he said would be the impact on him. And then at 97 and 98, well, at 97 it points out that he was cared for by his siblings while his mother was in prison. At 98 it refers again to the occupational therapist report, Ms. Goddard, and in summary it does accept that there would be, again, some impact on Altaf and also on the rest of the family who would have to step in if she were deported, but it doesn't accept that the effect on him would be as severe as claimed. And then 99, it says, we've also had regard to the fact that the appellant expresses remorse and there's no evidence before us of further offending. As I've pointed out, it's paragraph 17 of my skeleton. In fact, the evidence went slightly beyond that. There was a letter from a probation officer, page 63 of the supplementary bundle, if you require it. The Tribunal doesn't refer to that, but in fact it says that the probation service don't have any concerns about this lady and her reoffending, and that she's low risk. And I say that because, of course, in HA Iraq, Lord Hamblin says that simply not committing further offences isn't likely to be relevant, and what one is looking for is positive evidence that a person doesn't present a risk. And we say that was capable of being such evidence. But as I say, there's no reference to it. And then also in 99, final sentence, again a reference to the appellant's ongoing activities at the Derby Unique Centre, where she's said to play a very significant role. As I say, it doesn't seem to have been disputed that it was a genuine religious institution. And then at 100, it expresses its conclusions on very compelling circumstances. The appellant's protected rights, line 1, appellant's protected rights, whether considered collectively with the rights of others or individually, are not, in our judgment, such as to outweigh the public interest. So in reaching that conclusion, the only three matters which it says it has taken into account under subsection 6 are the effect of deportation on Altaf and indirectly the effect on the other family members having to step in to look after him. Secondly, the low risk of reoffending, or rather the fact that she hasn't reoffended. And thirdly, the religious activities. And what we say is conspicuously absent from that analysis is any reference to the numerous other relevant or potentially relevant factors, including the factors which could have, or indeed did, come under the headings of subsection 4 or 5. And I've set those out at paragraph 22 of my skeleton. And as I say, I'm just trying to restrict myself here to matters which were either accepted by the Tribunal and or not in dispute, and or as to which there was clear evidence which the Tribunal didn't say it rejected. So first of all, the appellant's poor mental health. As we've seen, the Tribunal accepts at 84 the evidence of the consultant psychiatrist, Dr. Wahid, that she suffers from depression and OCD. Found that that didn't help her show that she met the test in subsection 4. But what, if any, weight did it place on it in the context of very compelling circumstances? We don't know. Secondly, long residence. What, if any, weight was placed on her 37 years of lawful residence in this context of subsection 6? We don't know. Thirdly, separation from her husband. As I said, the Tribunal doesn't appear to dispute that he's very ill. It appears to accept that he won't travel with her to Pakistan. We know that the Tribunal doesn't accept that that by itself meets the test in subsection 5, exception 2. But we aren't told what, if any, weight is placed on it in the context of very compelling circumstances. And of course, the test under 5 would only involve the impact of separation on the husband, whereas the proportionality assessment under subsection 6 would involve the impact on both of them. That doesn't appear anywhere in the Tribunal's judgment. The fourth factor it didn't take into account under subsection 6 were the difficulties the appellant would face in Pakistan. As I've said, the tribunal did accept that she would naturally encounter some hardship, but not such hardship as to meet the threshold in subsection 4. But again, does the tribunal accept that is relevant as part of a cumulative assessment? And if so, how relevant? We're not told, again. And then the appellant, the limited extent of the family ties in Pakistan. As I say, there were extended family members in Pakistan, but the tribunal, as I've said earlier, finds that they may not have the space available to accommodate her for any significant length of time. Doesn't appear to have reached any conclusions in the context of subsection 6 on how or where she might live or be supported in the longer term. The highest it seems to be able to put matters in the final analysis is to say, as it does at 85, and again at 87, and I took you to those passages earlier, that there would be at least some support available to her, and that family support would buffer some of the stress that she would be under. Again, how are her longer term prospects factored in as a woman in her 60s with significant mental health difficulties? We simply don't know in my submission. And again, also there's the relationship with the other children and the grandchildren. Those are dealt with quite briefly at 94. Yes, well, the children at least are dealt with at 94, the grandchildren aren't. How is that factored in her favour? It's not entirely clear. All of those matters, we say, are relevant. They were matters on which the findings of fact of the tribunal were not by any means entirely adverse, even if the tribunal didn't accept the entirety of her case. And we say it's clear that those matters were not taken into account under subsection 6. And given that
I really am struggling with how you can say this, because we've had 43 pages of judgment before one gets to the consideration of subsection 6. Mm-hmm. And you can't just assume, you can't assume that the tribunal has forgotten about all the matters that it has previously dealt with. And what it concludes is that the appellant's protected rights, whether considered collectively rights of others or individually, are not such as to outweigh the public interest. So you accept it's dealt with all, it has dealt with all the factors earlier in its judgment.
But it's addressed them in a different context, yes.
Well, I know, but it's not a cut and paste job where you have to repeat everything again. It's indicated what the rights are. It's considered them in different contexts. And then it has reached its conclusion in 100. And we have to assume that when it's referring to those rights, it has in mind the rights that it has set out in some detail and analysed earlier in the judgment, don't we?
Well, assuming that it recognised that they were relevant, but we see nothing in the judgment to suggest that it did.
Well, we know everything's relevant. We know everything is relevant.
We do, my lord.
Well, we all do.
The question is whether the tribunal recognised that. And there's nothing from its judgment which indicates that it did.
Well, except that it says so.
Well,
it says balancing the rights of the appellant against the public interest and how the scales are weighted. And then but what it indicates, and of course, it seems to me, I don't see how we can really address this until we know how the case was put to the tribunal, but it says the focus was on the evidence, the impact of the deportation on the care and assistance she provides to her son. It seems to me the tribunal is perfectly sensible in addressing the one factor which appears to potentially take this matter above and beyond the aspects which it had said didn't amount to 4 and 5, and look at that one aspect in particular and say, even taking that into account, all the rights identified do not outweigh the public interest. What's wrong with that reasoning?
Because, as I've sought to argue, the question it was asking itself under 4 and 5 is not the same question as it has to ask itself under 6.
The tribunal for a moment thinks it is.
In which case, the question is, what does it make in terms of the multifactorial approach which it has to take under 6 of the matters which it has just looked at in the very much more, as it were, open and shut context of 4 and 5.
If they had added a sentence in, for example, paragraph 92, saying, for this purpose we take account of the findings we've already made, for this purpose we take account of the findings we've already made, would your appeal have legs?
I respectfully submit that it might do, yes. I mean, obviously depending on exactly how it expresses itself, because one comes back to this point that, as I say, Lord Justice Underhill articulates that it's perfectly possible that certain factors are not very significant for purposes of subsection 4, but nonetheless significant for purposes of subsection 6. Simply because one doesn't reach a high threshold such that one succeeds on the basis of 1 or 2 of these factors taken independently, doesn't mean that those factors are not relevant. It doesn't mean that a combination of matters not by themselves reaching the thresholds in 4 and 5 doesn't mean that that combination of factors can't succeed. That's got to be the nub of my case. And that's why it's not sufficient for the tribunal to simply say, well, we don't find that she's met these high thresholds, and therefore it's sufficient for us to simply refer back to those earlier findings. Because not meeting the high threshold in 4 and 5 doesn't mean those factors are simply discarded or that they're not relevant under 6. And that's why it's crucial for me to try and argue that the approach to be taken under 4 and 5 is very different from the approach to be taken under 6.
Right. Well, you explained that point. Is there anything further? Where do we go now?
I think that's probably what I would like to say at this point, unless it'll be of assistance to say anything else. I will perhaps park the question of whether it's relevant to look at the permission judgment until after my learned friend has said what he wishes to say about that, unless there's anything else.
No, thank you very much. Mr. Tabori.
Thank you, Lord. I'd like to look at the authorities and draw out certain points from them and then make certain submissions on the case against me for the appellant. Before I do, I wanted to just deal with head-on some of the points made orally by my learned friend this morning, just to, because I think they set helpful parameters as to where we are now as the matter before you. First of all, that in relation to, just starting with what's just been addressed, my learned friend's point about weight, and ultimately that what the tribunal didn't do is state the weight that was accorded to these factors when performing the subparagraph 6 assessment. The first point is one I've made in my skeleton, which is that they've been weighed, and so long as we can treat them as remaining in the game, as it were, as part of the cumulative assessment that is ultimately performed under subparagraph 6, there's no reason that they should have any different weight when other factors that don't fall within the exceptions are brought into play, for instance, relationships with an adult child. The second point is that insofar as my learned friend relies or seeks to say that there is a requirement to state the weight of factors previously considered when performing the subparagraph 6 assessment, in reliance on what Lord Justice Underhill said in Yeltsin, that was, you'll already have it noted, that was at page 344 of your authorities bundle, paragraph 62. I would simply say that that is not what His Lordship says there. It doesn't give support to that proposition, that submission. It was the line 7 lines down. A tribunal must, of course, in its reasons, identify the factors to which it has given significant weight in reaching the overall conclusion. So what that means is that when turning to subparagraph 6, you stress the matters to which you have attached significant weight. So exactly the approach we see here of focusing on that which apparently was the focus of the appellant herself, namely her relationship with Akhtar. Doesn't say that everything previously considered must be brought back and reweighed. It's not even clear that that proposition falls within the next sentence about what is desirable, but that, of course, wouldn't establish a point of law anyway. My learned friend
He says calibrating relative weights will often be an artificial exercise.
Exactly.
That seems to be what suggested that should have been done.
Yes, my lord. What I would say that is essentially talking about a scenario in which you, bearing in mind Yeltsin was a serious offender case, that you wouldn't have had inherently, as you do in the medium offender case, the grappling with the exceptions. So in the serious offender case, you might have greater requirement to consider matters that you haven't immediately already gone to, and then you have your broad proportionality assessment where you need to state everything in the round and consider everything, and potentially, as a matter of desirability at least, state their respective weight. But that doesn't clearly apply where you have already addressed these matters and weighed them. I submit that Justice Underhill is not saying that for the purposes of medium offenders, in the different exercise that requires, that you have to state the relative weight between the matters that you have already weighed, exceptions 1 and 2, and the new matters that are additional and fall within the broader European Court jurisprudence but aren't caught by the statutory guidance. The second point, just to carry on through some of the points made already by my learned friend, is my learned friend stated that describing the exercise as he says, in terms of how he says it falls to be determined, one has to mention the crucial ones, the crucial factors. So that I would submit as a key concession ultimately, because that's exactly what we say, exactly what the upper tribunal did. It's not a statement that you have to consider absolutely everything. It's in line with Lord Justice Underhill's statement that tribunal must, of course, in its reasons, identify the factors to which it has given significant weight. And it's, of course, logical, because why would you restate, copy and paste, for instance, matters gone previously? The third point that I want to pick up on was in relation to questions from my Lord Phillips, that as to whether this is really a reasons challenge. My learned friend accepted that. And that is particularly key because of the findings in Yeltsin in particular, which I was going to address in the course of my trying to set out the jurisprudence behind this issue, but I think it worthwhile to address head on now whilst I'm responding to these points. So if I could take my lords, my lady, to the key paragraphs of that case. They are at I think it would be helpful to start with what the upper tribunal in Yeltsin found that was overturned by Lord Justice Underhill's court. That's at paragraph 41 on page 337, tab 16. So you'll see there that what the upper tribunal found was, in fact, it may be helpful if I don't distract you and you read 41 and the insert quote to yourselves, please. Yes, and so the key word is, of course, expressly, and in paragraph 42 of Yeltsin, over leaf, page 338, within the inset quote, paragraph 36, you see it again in the upper tribunal's reasoning. It was incumbent upon the judge expressly to consider those exceptions. Then, if we go down to Justice Underhill's judgment at 59, he recaps essentially on what the upper tribunal had held. So just to set it in context, you may know the judgment well already, but serious offender case, ultimately the test is subparagraph 6 alone, but the upper tribunal here had said that not only is it helpful to start with the exceptions before going on to consider very compelling circumstances, but you must start with them. And indeed, to quote from Justice Underhill, the upper tribunal held that it followed from the judgment in NA Pakistan that the first tier tribunal was obliged, apparently as a matter of law, to consider expressly whether the impact of the appellant's deportation on his family in practice on D was unduly harsh, and then go on to consider whether there was something more for subparagraph 6. And then at paragraph 60, His Lordship finds that that approach is incorrect. And the paragraphs essentially at 62 to 64, 65 even, are all to the effect, in line with my submissions in this case, albeit from the different context of a serious offender case, where there's a sort of reverse position in terms of how the exceptions sit, all to the effect that you don't need to expressly consider the exceptions when you turn to subparagraph 6. Much as it might be useful to sort of measure up that which you are proceeding then to consider whether it amounts to something more. And if that is all the case, which it is, because this is the Vice President of the Civil Division, then the reasons challenge, as it's been clarified as being by my learned friend, cannot succeed. The next point, just picking up on my learned friend's submissions, is a much more minor point, and it's just about accuracy, but I didn't want to interrupt, and so I just quickly deal with it now. My learned friend said in relation to paragraph 84 of the upper tribunal's judgment below that that the upper tribunal said, we accept she's taking regular antidepressants as prescribed by her GP, and that she requires the emotional and social support of her children. What the tribunal said was, we accept she is taking regular antidepressants as prescribed by her GP, and that her children are providing her with emotional and social support. The next point, just sort of setting out what the case properly is now, the list of matters that my learned friend submits the tribunal below failed to take into account were each of them matters that he accepted were factors that were weighed under the exceptions. So I don't say that is the extent of my friend's case, because he of course talks about the matters falling outside it, but it is notable that reliance is put on those, because what that means is that if I am right that there is no need to revisit those factors, then the reliance on a supposed failure to consider those factors a second time round is not an error of law.
But it might be necessary to indicate that you have them in mind, in a broad sense.
My lord, it might. We don't necessarily need to. Wouldn't have to bear on this case, where for reasons you've pointed out, the judgment in respect to subparagraph 6 shows very clearly at beginning and end in particular of that section that there was that consideration. There's nothing there to suggest that I now shut out, I direct myself that this has no bearing, a la NA Pakistan, the original case on this issue. There's no express division there, or siloing of factors. But as to whether in the broader run of cases, and your obvious interest in the guidance to give, of course it might be helpful to pick up on Lord Justice Jackson's statement about it's helpful in respect to state, to measure the exceptions before moving on to the subparagraph 6, which is of course more relevant to serious offenders, because for medium you'll inherently already have done so. And it might be relevant in a medium offender case to say, these all stay part of the picture, just so you know, I bear the, and now I add to them as part of a broader analysis, X, Y, Z. But one, as I say, we have that here. Two, I don't say that as a matter of whether it's reasons or relevant considerations, that there is that necessity, because the way the appeal courts will approach a judgment is to read it in its entirety. It's not like a reliance on some sort of incorporated by reference extraneous matter. It's not even like the point my learned friend takes in his supplementary skeleton regarding reliance on the permission to appeal reasoning. It's all within the same judgment, so how can it be shorn off and said to be not part of the analysis under subparagraph 6?
Well, the case against you seems to be that what the tribunal was bound to do was to re-identify every one of the factors it had previously identified in the previous 40 pages and reassess the significance of each of those factors in the very compelling circumstances test.
Yes.
And so it would have been another 10 or 15 pages to do that exercise, when their ultimate conclusion was that none of those factors outweighed the public interest.
Yes.
And that, at the end of the day, is the question we have to decide, is the tribunal obliged to reconsider every single factor it has previously considered?
Yes.
And your answer to that, surely, is paragraph 62 of Lord Justice Underhill in Nelson.
62 to 65, well, as I just have taken you to already, those are where the law is at ultimately, and it helpfully arrived before your judgment.
Would, in my view, place an unrealistic burden on tribunals for them to have to decide and specify in every case whether the something more consists of the exception-specific circumstance being present to an elevated degree, or of some other circumstance or circumstances, or a combination of the two.
Absolutely.
That's obviously looking at the other way round,
Quite.
but it must apply in both directions.
Absolutely. Indeed, if you want extra confidence as to why you can read it across from the serious offender context to the instant, try and find. Yes, it's in paragraph 64, where the paragraph re-emerges from its inset quote. It's on 345. The court was taken to an HA Iraq, a medium offender case, and the principle within that paragraph in particular is that the tribunal will inevitably have considered whether the relevant exception has been satisfied. It's unnecessary for it to cudgel its brains and to make a definitive finding, and then in the, as I say, where it re-emerges, the effect of the over and above requirement was not the subject of argument in HA Iraq, and in any event, the point being made in this passage is not exactly the same as the point I've just been considering, but the spirit of it does seem to me to be the same effect. And that is what I'm saying. The spirit of Yeltsin is to the same effect as what I am saying, and allows you to read across. And what that spirit, what the principle is, what the spirit is, if you like, is the focus must be on the conclusion under subsection 6, and explicit findings on particular matters feeding into that conclusion are not in all cases required as a matter of law. That appears to be saying that even under 6, you don't have to set out absolutely everything. So never mind the things already gauged under the exceptions, even things that might pertain to 6. And Learned Friend relies on the impact on the appellant's husband, something that may not have been already been caught, but that was incapable of reaching the high threshold there, and wasn't something therefore necessary to provide additional reasons on. But what it certainly means, that statement about the focus must be on the conclusion, explicit findings on particular matters, not always required, what it certainly means is that you don't need to dredge back up your reasoning in respect to the exceptions. To similar effect, at the bottom, final sentence in paragraph 63, same page helpfully, it does not follow, and he does not say, that a tribunal is in every case obliged to make an explicit and particularised finding as to how that something more is made up. And that's Lord Justice Underhill's very helpful phrase to sort of encompass what subparagraph 6 is about. It's about the something more.
Actually, we do now have the skeleton. Thank you very much for sending it. And the submissions on subsection 6 are really quite limited.
Thank you, my lord. I hadn't seen that. So those are all the opening points they wanted to make. I want to, as efficiently as possible, given you've already had my skeleton argument, go through the relevant authorities. We've helpfully already dealt with Yalcin. And it's actually a good place to start because I would submit it confirms, given that my skeleton was written before Yalcin was promulgated, the approach that I was submitting in that skeleton should be drawn from the relevant authorities. To start with NA Pakistan, this is a foundational authority here. This is at your tab 8, in paragraph 27, page 159. The court proceeded on the basis that, quote, the fallback protection of the kind stated in section 117C6 avails both serious offenders and medium offenders. Just to pause there, that was, of course, the first great contribution of this very important case, is that even medium offenders should have that fallback protection.
I'm so sorry, Mr. Dwyer, my fault. Which paragraph are you?
That was 27, my lady.
27, thank you so much.
But in respect to medium offenders, it was medium offenders who fall outside exceptions 1 and 2. And that is important because elsewhere in the judgment, as we'll come on to, there is some unfortunate lack of clarity in the language, which this court has an opportunity to clarify as to what was meant there. But in this statement, at least, Lord Justice Jackson makes very clear that when it comes to medium offenders, the relevance of subparagraph 6 is to consider matters falling outside of the exceptions. So also in paragraph 29, sorry, turning to paragraph 29, which is on page 160, Lord Justice Jackson said, a foreign criminal, and that I just emphasise that phrase because that spans obviously medium and serious offenders, would need to be able to point to features of his case of a kind mentioned in exceptions 1 and 2, or features falling outside the circumstances described in those exceptions that made his case particularly strong. Now, my position, our position, is that the former of those, namely pointing to a feature of your case falling within exceptions 1 and 2, isn't relevant to the medium offender. Because if you could point to a factor that was so particularly strong that fell within those exceptions, you would have already satisfied those exceptions and you wouldn't be looking at subparagraph 6. So I think, as I said before, the use of a foreign criminal spans both. And that is why there is essentially the former is only relevant to the serious offender. In referring to, and my friends address this paragraph, it's important, 32 of NA, which is the reference to medium offenders specifically on page 160. His Lordship stated that, similarly, in the case of the medium offender, if all he could advance in support of his Article 8 claim was a near-miss case in which he fell short of bringing himself within exceptions 1 and 2, it would not be possible to say that he had shown that there were very compelling circumstances over and above those described in exceptions 1 and 2. And I submit that is fairly clear indication that His Lordship meant that medium offenders can't rely on features of their case of a kind falling within the exception. But the problem then arises in the same paragraph, in the next sentence, paragraph 32, His Lordship stated, that in principle, there may be cases in which such an offender, which still talking about medium offenders, can say that features of his case of a kind described in exceptions 1 and 2 have such great force for Article 8 purposes that they do constitute such very compelling circumstances, whether taken by themselves or in conjunction with other factors relevant to Article 8 but not falling within the exceptions. And there may just be sort of limits to my analysis of it, but I don't see that that works for the medium offender. It's difficult to see how a medium offender who doesn't satisfy the exceptions can nonetheless rely on the same factors falling within those exceptions to rise even higher to the threshold of very compelling circumstances without anything more.
Well, take this example, the 60-year-old woman who's spent 29 years of her life here. So she's out on the exceptions because she doesn't qualify for most of her life. But on the other hand, she's been here a very long time. She may be able to prove that she would satisfy the other elements so that she is culturally and socially integrated here and would face very significant difficulties in going back to whatever country it is. Now, why wouldn't that be a factor to be weighed, obviously against criminality, but I don't see why that wouldn't be a factor. She's failed the exception, but only just on one of the cumulative points that she has to satisfy.
If my Lord means that in that scenario there are circumstances that don't just fall short, but are something essentially not caught by, I think you have in mind exception 1, then that isn't merely a factor falling within exception 1. That is something else to be carried on, if you like, and considered in relation to 6. If exception 1 said well, ultimately, I think, my Lord, just looking at it afresh, that is...
I thought you were saying that this passage of the judgment doesn't work because somebody who doesn't satisfy exception 1 can't, yes, by reference to the same matters, satisfy subsection 6.
I would submit, my Lord, that that would not be sufficient alone. So to the extent that I think probably that is fully within, I think you have in mind. So let's assume that it is within, namely lawfully resident for most of C's life. That would be insufficient. But I think in reality, as I sort of began by saying, that goes beyond most of her life, because then you're talking about not just a sort of tipping point of more than half, but something more, some sort of enormous span of half a century or something, say. That's beyond. That's not something falling within exception 1, namely 4A. That is an additional matter that 4A doesn't really care about. but it is obviously something favourable that would have to be considered, would be considered in relation to 6.
Right.
But my point ultimately is that if it doesn't satisfy the exceptions, then to the extent that it is something within them rather than something falling without, and that we can test different scenarios where does it sort of straddle it, or is it properly within it or without it. But to the extent that it is properly considered within it, it is, and yet it falls short, I would submit that it doesn't work to say that it can somehow have a new lease of life at a greater threshold than it's already failed to meet. I don't know if that assists my line.
Yes,
We could try alternative scenarios as well.
No,
And maybe I'm just misreading
You
it.
carry on.
But
Is this relevant to the present appeal?
well, what it goes to, my lord, is just to confirm the proper approach in respect to medium offenders, and that you are required, when considering subparagraph 6 for purposes of medium offenders, to have something more, and you cannot trade on matters that fail to pass the relevant test in respect to the exceptions. Because if that's correct as a matter of law on the correct reading of 117C, then when a tribunal is applying that, then there is no reason to dwell in respect to subparagraph 6 on the previous matters, and there is full logical justification for focusing on the something more.
Which is what Lord Justice Underhill says.
Absolutely.
So we come back to, we've got a very recent decision of this court, which is all you need, isn't it?
Absolutely. I mean, maybe I will just skip to why. Well, that's why I was addressing it. But in terms of why it might be particularly relevant to your judgment, and you may think that it can be a much narrower, simpler judgment that needn't address that, but because you may have other factors, and certainly I believe a sort of host of reasons in support of our case here. But something that I would submit you can usefully address is this point. Potential difficulty in relation to NA Pakistan in that paragraph, and as to why sort of not endorsement of the points I'm making, but as that it's something that has occurred to others. If we could go on to, if we skip essentially a lot of what I was going to say and go to an earlier judgment by Lord Justice Underhill in, namely H.A. Iraq.
This is the passage in your skeleton.
Yes, you have it
Yes.
already, absolutely.
No, well, please do.
Just for your note, and to just remember where all that is, then it's paragraph 33 of that judgment, page 250, it's tab 14. And just whilst you're looking for it, I can just sort of add, I do say that cases such as the incident, although this judgment itself may sort of be sufficient just to see the fate of the appeal, but cases such as the incident and why permission was granted, why it was brought, are more likely for as long as this clarity isn't provided. So the passage there at 33 statement, in carrying out the full proportionality assessment, which is necessary where the exceptions do not apply, facts and matters that were relevant to the assessment of whether exception applied are not exhausted. If the conclusion is that they do not, they remain relevant to the overall assessment and could be sufficient to outweigh the public interest in deportation, either if specially strong by themselves, and there's a note there you'll see in superscript, or in combination with other factors. If we go to his superscript, his referent for the number 3, that's in at the end of the judgment on page 284. His Lordship confirms that that's not how he would put it ultimately, for which now see Yeltsin. Rather, this phrase reproduces what is said in the penultimate sentence of paragraph 32 of NA, but it is rather puzzling, and you can read the rest of that note. That is essentially what I am. Well, his lordship says it's puzzling and he's not sure about it, but he doesn't need to clarify it on that case. I am saying not only is it puzzling, but trying to assist in how it should be read, what the solution is ultimately. You may also say we don't need to determine it for purposes of our appeal, but I do say that is something of the legal wrinkle that lies behind this case, because if it were confirmed that in respect to medium offenders, when turning to the fallback, you don't need to revisit what you've said already. Then, and in fact, of the two ways in which subparagraph 6 can be met in any foreign criminal, for any foreign criminal, including serious, the only one of those is relevant to the medium offender. The one that is showing a particularly strong factor that falling within the exceptions isn't available to the medium offender would be helpful for the jurisdiction ultimately, and it supports my case in this appeal, which is why I rely on it.
I'm not sure. It is puzzling because if you're a near miss for exceptions 1 and 2, why as a matter of logic could that not constitute very compelling circumstances? Because you don't meet either exception, but on the facts of your case, you're pretty close to meeting both of them.
Well, without looking at the authorities that confirm it, it is, I think, accepted and established that subparagraph 6 entails a higher threshold.
Sure.
And so if you've near missed or any missed the exceptions...
But coming back to my example, which I know you would like, being socially and culturally integrated into the United Kingdom is a feature of a kind described in the exception. But if you can't rely on the exception because you've only been here for 29 years and 11 months, and you're 60 years old, it seems strange to think that you can't rely on your integration as a factor under subsection 6.
Well, my lord, this is where we need to be absolutely clear. It would be relevant in respect to the form of approach to subparagraph 6 that can be used for medium offenders, namely it stays in the picture but needs to be joined by something additional. So I am not saying that, absolutely not saying, I mean that would be to reverse NA Pakistan, that something like that.
Well, Lord Justice Underhill says it doesn't if it is something which is exceptionally strong in itself. That's Yeltsin.
I'm not sure which passage that one is.
Isn't that in Yeltsin? I thought it was.
Was that 62 we were looking at before?
57.
57.
Either because the circumstance in question
Yes.
is present to a degree which is well beyond what would be sufficient to establish a bare case.
Yes.
So if you posit a case of extraordinary integration,
Yes.
then that's enough in itself, even though you can't rely on exception 1 because you haven't been here for long enough.
Well, the first point is that this is talking about the serious offender who can't win on the exceptions. So he shows a factor that falls within the exceptions and says, I'm allowed to rely on that factor, even though it falls within the exceptions, even though I'm a serious offender, but it's so turbocharged that it rises to the well beyond for the test that I do have to meet. For purposes of the medium offender, if it doesn't exceed exception 1 or 2, then the test won't be met. If there's something in it that is simply not caught by exception 1 or 2, so say you have a particularly strong, extraordinary case on one of the 3 elements of exception 1, but you don't meet the others, well, that would be something that falls outside it and isn't caught by and doesn't fall within. Indeed, it falls without, and hence it can only be considered under subparagraph 6 as a something more, as a complemented by other relevant circumstances.
What you're saying is you can't be above and beyond if you're beneath and below.
Absolutely, absolutely. Yes, of course. So that's, I think, as I said before to my Lord Justice Males, that it will depend. There will be facts where you're considering, well, strictly, does this fall within, or is this a sort of something that is not caught by? And so that is the nature of the law here, ultimately. We're not doing away by the clarification I invite with the necessary case-by-case determination, but where it's found that these are all matters falling within, they'll stay relevant, but they'll need the additional matter if you're going to then win on subparagraph 6.
None of this is relevant to this appeal, is it?
Well, as I said, my Lord, I submit that it is. I think that my learned friend would not be venturing to say that it is necessary to bring in matters already considered in respect to the exceptions if this court had already decided that for the purposes of the medium offender, the focus is solely on the something more. Because from that it follows that a tribunal, like the one below you now, can spend its time on the specific factors, the putative something mores. So to that extent, not only does it support what I'm saying about this tribunal was entitled to so focus, but tribunals, parties would be assisted by knowing that. Because currently, see paragraph 32 of NA, they seemingly have to consider both of the strands of ways in which subparagraph.
But I think the case against you isn't based on focus. The case against you is based upon the fact that the other factors are relevant. The case against you is that because they are expressly recognised to be relevant in the authorities, that the tribunal has to take them into account and address them.
Yes, absolutely.
So I'm not sure.
I don't think either of us dispute their relevancy, but as my friend confirmed, this boils down to a reasons challenge and what has to be addressed. And I think a reasons challenge wouldn't have been ventured if the clarification already existed.
Well, I don't think Mr. Mackenzie has addressed us on whether or not on where the focus is at all. And it would be strange to think that, particularly given the way the case was put, the focus wasn't on the particular identified factors of the care of the adult child.
Well, potentially. Or, if my friend is right, and you essentially have to bring back in that which you've considered already, you might have some sort of balance sheet in which Altaf joins with everything already canvassed in relation to the exceptions, and it isn't given any particular greater focus. It would be a sort of very much more structured, formalistic approach.
But which is your submission? Is it that the tribunal did or must be taken to have considered all the factors that they'd previously addressed, or is it that they didn't because they didn't need to?
No, it is that they did, but they don't need express consideration. They don't need further revisitation. And lines such as, if we go from the authorities to the core bundle and the judgment and paragraph 94, my Lord already addressed, we are prepared to accept the appellant as a strong family and private life in this country. No doubt enjoys a strong relationship with all her children, but the focus of the evidence before us was on... That is a taking stock and a reference back of in relation to matters already found.
Exactly. I mean, the irony is in the way that it was put by Mr. Mackenzie in his skeleton was referenced back. He said, as to the position on the return to Pakistan, for example, KA relies on the matters set out above. And that's the way he dealt with it. And actually, there's some correlation between the way the tribunal dealt with it in their decision making and the skeleton. That was
Exactly. Very, very good point. Yeah.
So it's very hard to see what the criticism is.
Because of the logic in it. Ultimately, you're a judge hard pressed to write a judgment, and you don't, for the sake of it, just copy and paste. And there'd be real risk if ultimately the Court of Appeal said, well, you probably should bring it all back in as part of this broad proportionality assessment, given that it's basically the same matters, you can copy and paste it, because that way leads to oversights and departure from proper judicial decision making.
Well, presumably you can say, by reference to paragraph 92, that the tribunal didn't know what they were doing, because they said the appellant's got to show that there are very compelling circumstances over and above those in the exceptions to deportation, which suffice to outweigh the public interest.
Absolutely.
And you'd say, well, they've already looked at those circumstances,
Yes.
and what they're now looking to see is whether there are other circumstances over and above the circumstances they've already rehearsed.
Yes, exactly.
But then in 93, it refers to the fact there's a scales.
Yes.
And 94 refers to certain of the factors.
Well, look, the scales and the fair balance, etc. You took my friend to reference to the balancing exercise. I think it's the final paragraph in this section at 100. Not in our judgment, such as to outweigh the public interest. Talks about proportionality. Because there is, notwithstanding that there is a sort of focus permitted and indeed logical under subparagraph 6, very compelling circumstances over and above test, it is a proportionality assessment. It's just that when you're discharging it or performing it, you don't need to explicitly, a la the upper tribunal overturned by Lord Justice Underhill and Yeltsin, restate all those matters.
Right, where do we go with your submissions now?
So I think that's probably sufficient on the law. You have my point about, I mean, I had more to say, but I think in the interest of time I won't go more over them. But just to summarise what I would have said beyond that, which you'll see in my skeleton argument, the individual cases in NA Pakistan are illustrative of the approach that I would advocate, in particular, and particularly useful for the instant case with its particular facts. Can I recommend the case of WM Afghanistan, another medium offender. So anyway, the only other...
I'm so sorry, could you just give us the paragraph
Yes.
references for that consideration in the judgment in any Pakistan, please? Begins at 82. It's 82 to 97.
Yes, exactly.
Thank you.
171 of the bundle.
Thank you.
So, away from those authorities, you have helpfully, Yeltsin, as my lord says, almost gives you all you need in terms of the approach now, leaving aside the option of clearing up the approach in respect to medium offenders that I've invited you to. The only other point of law to bear in mind, somewhat trite, that we can take from Yasin for its summary there, but an important one to stress. You'll find under the issues on this appeal, page 340 to 341, paragraphs 50 to 52. You'll have read these where I rely on them in my skeleton, and you'll know them anyway. Lord Hamblin in HA Iraq, paragraph 72, which is also in your bundle if you want to read it in its original context. Well established that judicial caution and restraint is required when considering whether to set aside a decision of a specialist fact-finding tribunal. In particular, the first subparagraph is about they alone are judges of the facts, their specialism. Roman numeral 2, where a relevant point is not expressly mentioned by the tribunal, the court should be slow to infer it's not been taken into account. So it's not just about you were the tribunal of first instance who looked the witness in the eye, etc. It's broader than that. It's about relevant considerations, which is, of course, relevant to this ground of appeal. And thirdly, when it comes to the reasons given by the tribunal, the court should exercise judicial restraint, not assume that the tribunal misdirected itself just because not every step in its reasoning is fully set out. Also relevant to this de facto reasons challenge. Now, at 52, Lord Justice Underhill says that doesn't apply when we are considering an appeal from what itself was an error of law appeal, as was the upper tribunal's decision in that case. In our case, the upper tribunal remade it. It was a first instance decision. So all those principles from HA Iraq, also AA Nigeria, or just Popperwell, do apply here. That's the law. Turning to my submissions, further submissions, made a few already. The first is essentially a factual one which we've already sort of been over a bit already, which is that irrespective of any question as to whether as a matter of law it is necessary to reconsider or touch on matters already set out, weighed, calibrated, etc., a few lines above, there's no evidence in this judgment that the upper tribunal did limit itself to considering matters not already canvassed in respect to the exceptions. And it was here that I said that amongst the reasons I gave in support of that submission, I referred to the permission to appeal decision, where the judge below said that he had all regard to all material evidence and regard to the evidence before it as a whole. That's in his refusal at paragraph 6, which is paragraph 16 of your bundle. You have my supplementary skeleton on that. I don't think it's going to be massively important in the run of the case. If you have questions about it, I can address it. I think would be the proportionate way to address it now. Perhaps the strongest submission I had in writing there was the reliance on the case of Tiva, an appeal from the Patents Court, which is perhaps particularly relevant, not only for what it said there, that the Court of Appeal will always be assisted by the trial judge giving full reasons why permission to appeal was refused, and not also not only because Lord Justice Kitchen, as he then was, agreed with Lord Justice Floyd's statement of that. Lord Justice Kitchen, of course, judge of particular seniority, becoming, but also that this was a case in particular about how, with the advent of the CPR, a distinct approach to appeals from, or permission to appeal from the Patents Court wasn't tolerable. Ultimately, the fact that there was a particular technicality in those appeals didn't mean that a different approach was necessary. So it's very much an appeal focused on the approach generally in the under the CPR, under CPR 52, and therefore to your decision too. And so if, in that case, which is essentially talking about the CPR generally, their lordships said that it's always helpful to see the permission to appeal refusal, I would invite you to consider that is helpful to you too, basically. And then from that, if it's always helpful for you to see it, it cannot be wrong for someone in my position to recommend it to you as assistive, is essentially the point. But as I say...
but it's not part of the reasons for the decision, is it? Because the reasons for the determination are in the determination. Absolutely,
my lady. And you'll see from my supplementary skeleton that I distinguish the case of Crayem that my learned friend relies on, which was a case about reasons where there was an impermissible attempt to sort of bolster and add reasons in the permission to appeal. Refusal, this, although it's now clarifying as a reasons challenge, was put more in terms of an error of law, ultimately, a failure to follow a correct approach. And in that context, I would submit that it is permissible to consider the court below saying what their approach was. It's not merely an attempt to add an additional reason. Indeed, the mischief in Crayem and was quite particular to reasons appeals, grounds of appeals. I've just to complete this first submission that, as a matter of fact, there's no evidence the upper tribunal did limit itself to considering matters not already considered under the exceptions, would also rely on a point already made in relation to the statement at paragraph 94 that we are prepared to accept the appellant has a strong family and private life in this country. That, as I've said, can only mean matters already considered, albeit, of course, shorthand for it. Then, in terms of the law and what was actually necessary, irrespective of the facts, as already submitted in relation to the law and the authorities, which confirm that it's necessary to identify something more, and you can't succeed as a medium offender by showing a sort of exceptions plus, if you've already failed to meet the exceptions. It wasn't necessary, I say, for the upper tribunal to spend more time than it did on those matters. And then just to add, the tribunal might choose to expressly state at the outset of its section on subparagraph 6 something along the lines that Lord Phillips suggested, but that isn't necessary. That would be in line with statements of what Lord Justice Underhill thought desirable. Lord Justice Jackson thought it might be helpful in the context of serious offenders to measure the exceptions first before considering whether there is something more, but it's not mandatory. It's not a requirement of law. This, and just to summarise, would invite you to find that this judgment is a cumulative assessment involving both the factors considered under exceptions 1 and 2, and that in general that is the approach to reading a case like this, a judgment like this, unless there is contraindication due to a misdirection. Let's recall that the NA individual cases all involved the ones
an
that
explicit misdirection.
Exactly. Which again, of course, particularly important given what we've seen from the HA Iraq Lord Hamblin principles, which talk about unless there is misdirection, presume. So the second point was going to be that the judge below correctly directed himself in accordance with section 117C6. We've already canvassed that already. My lady's taken me to the paragraphs where that occurs. The third submission and was to say that it was essentially, as already addressed, that it was legitimate and exemplary, effectively, to focus on the relationship with Altaf, and why, in respect to NA Pakistan, another of the individual cases that is instructive is the case of MY Kenya, which is at paragraphs 103 to 106 of NA Pakistan. Was essentially that. In fact, that was the one that I had in mind as being particularly useful. So, if I could, for your note, or if you want to look at it, paragraph 105 of NA Pakistan, which is in the Authorities Bundle 174. This was a relationship with an adult child, a severely disabled adult child. It makes sense, but a child of the relevant individual who was an adult, and reference to Kugathas. And it was a case where, due to the particular facts of that case, subparagraph 6 was satisfied. But of course, I wouldn't rely on that for my case. But factual precedent doesn't exist anyway. But what it does show is that even though the exceptions weren't satisfied, in a case like this, where you have a relationship, you have a child who is an adult, that is why you might focus on that at the subparagraph 6 stage, and that is what happened in the MY Kenya case before Lord Justice Jackson, and that is what happened in the decision below. So that it is essentially demonstrates the relevance, the potential relevance of subparagraph 6 to medium offenders. Then just to address a couple of discrete points made by my friend in his skeleton regarding, it was stated that in only having regard to, in only stating briefly that there is no evidence before us of any further offending, the tribunal somehow disregarded further evidence, which the appellant says went beyond a mere absence of offending. Famous skeleton at paragraph 19. But I would submit that the evidence that the appellant actually relies on is materially equivalent to what the tribunal says, namely an email from the probation services stating that, quote, they do not have concerns about the appellant and her reoffending, and that she was low risk on our records, which I take from just referring to this famous skeleton at 19. And I would submit that that doesn't add an additional factor or matter, because it is not, quote, to quote from H.A. Iraq in the Supreme Court, which looked at rehabilitation, it's not evidence of positive rehabilitation which reduces the risk of further offending, that's paragraph 58, 308 of the Authorities Bundle, or of reduction of risk. Contrast the rehabilitation evidence in Olaredwu, on which my friend relies, at paragraph 21.2, which is Authorities, page 193, where, quote, which was, just to add, was held insufficient, but nonetheless contained evidence from professionals that he turned his life around. So this is reading from 21.2 of Olaredwu, page 193. Evidence of the professionals was that he turned his life around and now acknowledged his past mistakes, had an understanding of how his offences had adversely affected society, has obviously affected professionals in a significant way, because both his key worker and his social worker, who travelled from Devon for the hearing, had attended the hearing to give evidence on his behalf. He now lives away from the area in which he became involved in criminal activities, etc. So that is evidence that might go beyond, and be worth noting, beyond absence of reoffending. And I would submit that without such evidence, the tribunal should in any event be cautious about their ability to make findings on the risk of reoffending, which is, I take from Lord Justice Underhill in H.A. Iraq at 141. If I could please take you to that. It's at page 283 of the authorities. In the final sentence of 141, page 283. If you could please read that.
Would you say that the tribunal was wrong in excuse me, in what they said at paragraph 99? I mean, they say they've taken account of remorse and absence of evidence of further offending, and of the letter from the counsellor and the religious centre.
No, I absolutely wouldn't.
Right.
No.
I mean, they've taken account of those points in her favour, but
Yeah.
nevertheless the balance comes down as it does.
Exactly. So it's not properly considered disregarded anyway. But to the extent that it's sort of hazarded that some sort of broader evidence of exists beyond simply lack of reoffending, that there isn't the evidence on rehabilitation that is necessary in the deportation context to actually add anything more than that.
Right.
As to the effect of separation from her husband, this was considered, so really it's the same point, but it's just that because it was considered in relation to the exceptions, see paragraph 70 to 87 of the Tribunal's judgment, pages 54 to 62 of the core bundle. It was also considered as part of consideration of her husband's separation from her, paragraphs 88 to 90 on page 63. It was not a factor like, for instance, the relationship with Akhtar that was not caught already and so had to be given particular consideration.
I don't think the first of those references you gave us says anything about the relationship with the husband, does it?
So I'll go to it, 70 to 87. I mean, it's in the context of her, it's considered in the context of her reintegrating as a single woman.
Yeah, it's all about how she'll get on in Pakistan. And whether she'll have somewhere to live and what her health difficulties will be and so forth.
Yes. Yes, I would accept that.
I mean, I suppose the most you can say is that the premise of that consideration is that she will be separated from her husband.
Indeed. Indeed, it's...
I mean, the separation point is really made at 88, isn't it?
Yes. And 89 and 90.
Yes.
I don't understand the point against you to be that the tribunal didn't give sufficient weight to these points. The point is that it didn't mention them at this stage of the argument.
Yes.
That's the sole point against you.
But that I have addressed
So
already.
I'm not sure going through them all and saying, well, they don't have much weight or they have already been addressed.
Yes.
It's constantly the same point over and over again, isn't it?
That's absolutely, my lord. To the extent that it's already been considered, yes, it is that same point.
Well, also saying this doesn't have much weight, again, it doesn't help, does it? Because that's not the focus of the criticism.
I mean, the criticism is, as my lord says, that when they get to paragraph 92, they either forget what they've just said in paragraph 90 or they disregard it.
Yes. quite, which we've covered. And I think I'll just finish with this point that given the sort of multiple statements as to the height of the threshold for subparagraph 6 purposes, if I give you sort of a list of, you'll find them in my skeleton argument, in fact. Just a moment, I'll give you the paragraph. It's the final paragraph, inevitably, paragraph 54 of the skeleton, from Hesham Ali in particular. Given that height of that threshold, the additional point to bear in mind is a causation one, a materiality one. Of course, my lady addressed causation at our permission hearing, but to the permission stage threshold, but it remains relevant here. And its relevance is to say that even if there were some sort of relevant consideration duty to bring back in and have regard to these factors, what difference would any of them made in what prospect would they have had of taking the appellant to that something more higher elevated threshold? We say none at all. And so it would be an immaterial disregard, and therefore not an error of law at all. Unless I can help you any further, my lords, will they?
Thank you very much. Mackenzie?
A few brief points, if I may. I believe my skeleton below has reached at least some members of the court, and as
Yes.
my lord observed, it is absolutely true. I accept that the submissions I made in it under subsection 6 are briefly set out. In my defence, I think I would point out that I did expressly say that the tribunal needs to take into account all of the matters they've already looked at under 4 and 5, including long residence, health, prospects in Pakistan. Now, I didn't obviously repeat all of those in detail, and I didn't need to. And I'm not suggesting that the tribunal needed to. I'm certainly not intending to go behind the many cases which have said that reasons can and should be expressed concisely. But what I do say is that they needed to make clear that they recognised that those were relevant factors. Certainly true, as my learned friend says, that they didn't expressly direct themselves incorrectly. They didn't say these are not relevant factors, nor did they say that they're relevant factors. So in the absence of a clear direction either way, one has to look at what they actually did. And the question is, did they look at these factors in the context of subsection 6? And the answer, in my respectful submission, is no, they did not. And to pick up, following on from that, my lord's point about the 60-year-old who's been here only 29 years. Now, that person doesn't meet 4. So would it then be sufficient for the tribunal to say under 6, either expressly or implicitly, well, we've already looked at that under 4. We've already looked at her length of residence under 4. And so we don't need to mention it again, or we don't need to consider it again. Well, we say not. We say clearly not. Because that simply means that it doesn't get considered at all. Because it's not relevant under 4. Because it doesn't meet the specific threshold. And then under 6, it gets looked at, but discarded because it's already been looked at. So that approach, as I say, in my respectful submission, would result in important factors not being considered under either 4 or 6. And if that's correct, then it applies to any of the factors capable of being considered under subsection 4 or subsection 5, albeit not meeting the specific thresholds. Not sufficient to say, well, we looked at those already, or simply to ignore them, because it essentially means that they don't get looked at all in the multifactorial assessment. And the fundamental question under subsection 6 is what one might call a classic proportionality approach. the balance sheet approach approved in Hesham Ali. And it doesn't, in my respectful submission, that's clear from H.A. Iraq in the Supreme Court, doesn't require to be over-complicated. And there's a danger of doing so, in my respectful submission, and it's very much that Lord Justice Underhill is warning against in Yelchin. And I do invite the court respectively to approach Yelchin with some caution. The question it had to answer, the question the court had to answer, is the one set out at paragraph 59. Let me just find that, I'm sorry. 344. Yes, so the tribunal held that it followed from NA Pakistan that the FTT was obliged, apparently as a matter of law, to consider expressly whether the impact of the appellant's deportation on his family was unduly harsh, and if so, to identify what was the something more. And this is in the context of a serious offender, of course, so the unduly harsh test doesn't assist him by itself. He can't win on unduly harsh. So the question, essentially, is do you need to consider the exceptions, even though they aren't relevant to a serious offender, before you go on to consider very compelling circumstances? Do you, as it were, need to squeeze through the door of 5, unduly harsh, before you get to 6? And Lord Justice Underhill is saying no. On the basis, as he says at 62, that one doesn't want to overcomplicate these matters. And he certainly doesn't say, however, in my respectful submission, that the key reasoning does not need to be set out when one comes to look at 6. So yes, I mean, my case does, as the court has, with respect, observed, come down to whether it is sufficient for the court, for the tribunal to have addressed these matters under 4 and 5. Did it need to look at them again? As I've said, using the illustration of the person who's been there only 29 years, the answer to that is yes, they did need to look at them again. And it's not sufficient. And they could have done so briefly, but it's not sufficient simply to overlook them. And it's not sufficient implicitly to have pointed back at its earlier consideration where it was considering a different test. I don't know if it would assist the court at all to be addressed on the question of the PTA judgment. You have my submissions on that, I think.
No.
In that case, I will leave it there unless there's anything else I can assist with.
No, thank you very much indeed. All right, well, thank you to both of you. We're very, very grateful for your submissions. We will reserve our judgment. In due course, it will be circulated to you in draft. It will have an embargo on the front page, to which you must pay close and careful regard. And we hope and expect that, in the light of whatever we decide, you will be able, between you, to agree in terms of an order for us to consider. If you find that you can't, then we will have short submissions in writing, and we will deal with that without further hearing. The judgment will be handed down remotely, so there'll be no need for any further attendance. That concludes the hearing, so thank you all very much.
All rise if able.